Hello, this is Brian Kyle with another video to help you pass the California baby bar and the bar exam. So we're going to continue with another question for remedies, and this is from July 2017, question 3. So here, the call of the question says, what is the likelihood that Rick will obtain a temporary restraining order, discuss a preliminary injunction, discuss, and specific performance? Now, I think that this is, very straightforward. They're basically telling us to analyze just one cause of action under each number. So I would first separate these into parts. And when it comes to one, I would write TRO, preliminary injunction, and specific performance. So they're asking us to analyze equitable remedies, right? Because temporary restraining order, preliminary injunction, and specific performance are all part of the bigger umbrella, which is equitable remedies. So let's read the question, the fact pattern, and see what we can derive from reading what's happening here. So Rick Retailer owns all pieces but the queen of a chess set carved by Anituk, a famous artist who carved the 15 chess sets. No one today owns a complete Anituk chess set. Okay, so we have so here. Let's talk about the main character, Ricky Taylor. All right, this is just a mental note. He owns all pieces but the queen. Um, for a Anituk, which is a famous artist who carved 15 chess sets. And no one owns a complete Anituk chess set. So it means it's rare, and I guess if you own everything, it may be worth something. So let's read on. 6 existing Anituk queens are owned by collectors. Okay. The last one sold in 1983 for $175,000. The current owners have refused to sell their queens to anyone. Okay. Um, so Rick Retainer has a set, only missing a queen. No one owns a complete Anitek chess set. In the market, there are 6 queens. Market. The last one in 1983 sold for $175,000. If Rick could exhibit a complete Anitek chess set, he would draw people worldwide who would buy memorabilia with pictures of the full chess set and other products. It is impossible to know exactly how much Rick would make, but a complete anti-tuck chess set could be worth in excess of 1 million. All right. So if he gets one of these, uh, it could be worth 1 million, right? Okay. I see why he's trying to get one. All right. Last week, Sam Seller brought to Rick an Anituck queen he found in his attic and asked if it was worth anything. Okay. So we have Rick Retailer and the second man, Sam Seller. And he brought the queen, asked Rick um, if it was worth anything, and Rick asked what Sam wanted for the queen, and Sam asked whether 450 would be fair. Rick replied that 450 would be fair and offered to write a check immediately. Okay. Rick and Sam entered into a valid contract. Sam agreed to hand over the queen the next day. Okay, so there was a valid pay between Rick plus Sam for 450. The next day, Sam called Rick and said, I learned that you defraud people out of expensive antiques all the time and that the queen is worth thousands of dollars. I am going to sell the queen to another collector. All right, so we have the seller who's not happy because he felt like maybe misrepresented the actual value. This is it, maybe, because we would have to go through the elements of what is a whether it is a misrepresentation, right? And in order for us to do that, we're going to have to go through whether there was a false statement of fact, present or past, things like center, whether he knew about or knew or had intent to lie about it, whether there was inducement, reliance, things like that, whether it was material. Well, let's see. So from this mishap, we're trying to represent Rick. We're not representing Seller. That's an interesting thing. All right. And he's suing for specific performance of, or breach of contract and saw a temporary restraining order and a preliminary injunction. Okay. So I guess we're going to have to talk about temporary restraining order. So temporary restraining order is to preserve the status quo, and usually we have to talk about things like irreparable harm, you know, balance of hardship. We usually have to talk about things like likely likelihood that he will prevail, and basically no defenses. Also, we have to mention that it could be done without notice to the other party. Ex parte, no notice, right? So, will Rick suffer irreparable harm? We're going to have to go through all these. Um, well, yeah, because, not getting this 450 or the queen that's worth a lot more, but they bargained for the queen at 450. So not getting that is obviously going to affect him because he was going to sell the set, which could be potentially worth $1 million, right? So yes, he can claim that he would suffer a financial setback, which would translate to an irreparable harm. Now, balancing the hardships, you know, Rick would also have an argument for balance of hardship because for Sam, he would just have to hand over the queen at 450 and he wouldn't be losing as much money as Rick. But Sam could also counter by saying that, he would also lose potentially thousands of dollars as a result of selling this for just 450. So I guess that could be arguable. Again, from that, we're going to have to try to argue that Rick has a good chance to prevail under temporary restraining order, and it could go both ways, but I would try to argue on Rick's side and use the facts to establish that chances are he'll probably prevail if he wanted to argue TRO. Now, no defense, latches. I guess there is an argument for unclean hands because Sam could argue that Rick failed to disclose the true amount of what this queen was worth. But Rick can say something like, he didn't make any false statement of past or present fact, and he didn't say anything in particular that would make Sam rely and would induce him to sell it for 450. So again, that's arguable. This unclean hands is arguable for temporary restraining order, but we're gonna still have to conclude. So chances are, at least until the trial starts, to maintain the status quo, the court will probably side with Rick and grant him the temporary restraining order. And I would just conclude with that. Now, for preliminary injunction, I would use the same pattern: irreparable harm, balancing of hardship, likelihood of prevailing. Another thing is that there is inadequate legal damages are inadequate. And lastly, what's important is that it can't be done ex parte. It needs to be done by giving the opposing party notice. And I would go through the same analysis going through these two, because this item was such a unique item that replacing it would be impossible. That would be Rick's argument as well. On the other hand, Sam would argue that even though it's unique, there's still six queens in the market, but having six queens is still unique. So this legal damages and inadequate argument will probably favor Rick. And again, we already mentioned that there's got to be notice. So for preliminary injunction, we would have to go through these elements and conclude that just like temporary restraining order, until the judgment, to maintain the status quo, to preserve the status quo, the court will probably grant Rick with a preliminary injunction, right? So that's already number one. That's already number two. Number three, specific performance. We always do this everywhere. So, I mean, we're going to have to talk about whether there was a contract with certain and definite terms, legal damages, inadequate. Courts usually look at feasibility, also mutuality. Here we can mention whether it's unique. And lastly, we usually talk about the specific performance, no defenses. Right. So here, was there a contract? Yes, because we talked about this earlier, that there was a valid contract between Rick and Sam for $450, right? And the terms were definite and certain, so it passes the first element. The second is whether legal damage is inadequate in this case. Yeah, because we talked about the uniqueness of this chess piece, and replacing it would be near impossible because there are only six queens in the market. And the last one obviously sold for 175,000, and getting this is almost impossible. So legal damages inadequate, passes the test. Whether it's feasible for the court to make each party perform and oversee it, that is something that I'm going to have to think about. I would probably argue both sides. Obviously, Rick is going to say that it is feasible. All the court has to do is to make Sam perform his end of the deal at 450, and the court just needs to oversee this valid contract. So it wouldn't be so hard for the court to see what's going on. Obviously, we're going to have some argument by Sam saying that is still a complicated issue, yet I get the feeling that feasibility wouldn't be a big issue for Rick. Balance of hardship or mutuality. Again, Rick, the fact that not having this chess piece for 450, although it's going to be a financial loss, and for Sam, he may also lose lots of money due to not knowing the true value of the chess piece. But because Rick can argue something like, you know, he almost has a set, and missing that would, you know, lead him to lose this much amount, a million. But Sam can probably argue under defenses, something like, obviously, we have to always talk about unclean hands. We have to always talk about latches. But we can, I guess, say something like misrepresentation, saying there was a false statement of fact which induced Sam to execute this contract without knowing the real value. And because Rick didn't tell Sam the true value of this piece, he relied on it, and this reliance was material to the contract. So we're going to have to go through, spend a little bit of time with misrepresentation, but looking here, the issue is when Sam asked whether 450 would be fair, Rick replied that 450 would be fair. So is 450 a false statement? Um, I get the feeling that it's not necessarily a false statement. Maybe he didn't disclose, the real amount, but whether he had center in his brain, whether he had the intent to defraud or knew about the fraud, that he was going to commit fraud, that would be arguable. And it's definitely worth mentioning, other than unclean hands or latches. I think that misrepresentation would be something that Sam can definitely bring up, whether or not it passes every element. It's kind of 50-50. I do think that Sam has an argument, but in the end, whether or not there was a past or present statement of fact that was false, I don't think that there was a false statement. It was more like a failure to disclose. But with pricing, I don't think that would rise to the level of misrepresentation. But hey, you can definitely argue it both sides. So I think that's it. I mean, we did TRO. That's question number one. We did preliminary injunction. That's two. We we just did specific performance, and that's three. And unless I missed something, that is probably the easiest, not latches, remedies question that we've done so far. Just remember that we have to stick to the call of the question and answer what they're asking for instead of being very broad and going into random things. We organize it by the question and make sure we're thorough with whatever they're throwing us for each number, which is, again, number one was TRO, number two was preliminary injunction, and number three was specific performance. So with that, we're going to finish this video. I hope that was helpful for someone out there who's struggling to understand remedies or just need to refresh their brain on how to do these questions, or if you forgot them, and you have to come back to these concepts again, and you're a little bit foggy in this area. I hope that this was a helpful video for you. And in the next video, we're going to cover the rest of the remedies question. So I want to thank you for watching this video again, and I'll see you next time.